Mr. Chair, members of the committee, thank you so much for the opportunity to present Senate Bill 841. Under current law, the Office of Public Defender can apply for government grants, private gifts, donations, other sources of funding, but right now that money gets deposited into general revenue. So this would just create a fund and streamline the process so that that funding gets directed where it's intended. This bill should be familiar to you all. We've heard it a number of years. It got TAFP'd last year, but unfortunately that bill is vetoed, so we're hoping we can get it done this year.
And vetoed on unrelated grounds.
Yes, thank you for that clarification.
Perfect. Any questions for the bill sponsor? Seeing none. First witness in support of Senate Bill 841.
Good morning. I'm Greg Mermelstein. I'm the Deputy Director and General Counsel of the Missouri Public Defender. I will be brief. Our Director, Mary Fox, was unable to be here today. As Senator Arthur has explained, this bill will allow the Public Defender to receive gifts and grants. The reason that we need this bill is because in 2020, there was a generous private donor in Boone County who wanted to give money to the Public Defender to allow us to hire contract counsel in Boone County. We discovered that we were not able to accept that gift directly because had we done so, the money would have had to be deposited in general revenue, and we could not assure the donor that the money would be used for the purpose that the donor intended. So we would like to have a fund that would allow us to solicit private gifts to be able to fund public defender services and help alleviate some of the burden or the cost on the state of Missouri in providing those services. Additionally, there's currently pending something in Congress, I believe, called the Quality Defense Act, which will, if it passes, provide federal grants to public defender agencies which work toward reasonable caseloads based on national standards and which have certain data collection and reporting capabilities. We already have the data collection and reporting capabilities, and with the support of the legislature, we've been working toward reasonable caseloads to meet national standards. So we anticipate in the future there will be federal grants similar to those that come from the Department of Justice for prosecutor offices that will become available to public defender offices, and we would like to be able to accept those and use those for that purpose. So for these reasons, we are supporting the bill and hope that you will as well.
Thank you for your testimony. I do notice that we have a quorum present, so Harley, could you go ahead and call the roll?
Senator Luetkemeyer,
Here.
Senator Schroer, Senator Coleman, Senator May,
Here.
Senator Roberts, Senator Thompson Rader, and Senator Trent.
Any questions for the last witness? You're fine. Seeing none, further witnesses in support of Senate Bill 841. Seeing none, any witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on Senate Bill 841. Next up, Senate Bill 887. Senator Washington, whenever you are ready. Just step that. Okay, real quick. We'll see it around. Okay. Next up is Senate Bill 765.
Good morning. Good morning. I want to thank Chair Luetkemeyer as well as members of the committee for the opportunity to present this important bill today. So a lot of you may be familiar with this bill from last session. The purpose of the bill is to provide a second chance for people who might have made a mistake at some point in their life. I'll admit that we all could point to folks, including ourselves, that have made mistakes before, and we all should agree that it shouldn't ruin their lives forever. So this bill will make an effort to make sure that people have a second chance at life as well as give them an opportunity to be productive members of society. I want to be clear about something. In 2021, we passed Senate Bills 53 and 60, and that reduced the time that someone has to wait to file an expungement after they've completed their mandatory supervised release. But during this time, they have trouble finding stable employment and housing, and the recipe for this is clearly recidivism. And that's exactly what we're trying to address with this bill here. I'd like to also highlight a key provision of this bill that would remove the cap of the number of records that can be expunged. And this provision is critical because it'll make sure that people can truly restore the rights and have an opportunity to move forward with their lives. I'm also aware of some uncertainty in the language about access to the records, and my office is committed to working through that language to make sure that it gets cleared up and everybody's comfortable and on board. So thank you, Mr. Chair, for the opportunity, and I look forward to any questions of the committee.
Thank you, Senator Williams. Just to clarify for the benefit of the witnesses, so we've got two of Senator Williams' bills up before us today. The one at the moment before the committee is Senate Bill 765, which, among other things, creates the conviction review unit.
Do you want me to speak on?
Yeah, if you wouldn't mind doing that, and I know that you've got a committee substitute that I think you're presenting on, so if you wouldn't mind presenting on that,
sure.
And then whenever we get to the next bill, we can just move through that a little more quickly, I think then.
Okay. All right, cool. I'm not sure what that static noise is, if it's me or not, but so we have a committee substitute as well, and the purpose of this bill is just to make sure that our courts are fair and just. So, one, we all know if someone breaks the law, then they should be clearly held accountable, but no one should be punished for a crime that they did not commit. As we know, that is not justice. So, Kevin Strickland is a prime example of why this bill is important. Mr. Strickland spent roughly 43 years in prison for a crime he did not commit. And thanks to the work of this committee and our colleagues, Senate Bill 53 and 60 provided an opportunity for Mr. Strickland as well as Mr. Lamar Johnson to finally experience freedom as adults. If there's any other individuals like Mr. Strickland or Mr. Johnson who are currently serving prison sentences for those crimes that they did not commit, the bill aims to create a pathway to freedom for them. Jackson County and St. Louis County has the capacity to review these cases internally, but however, there are many counties throughout the state that may not have the infrastructure in place to provide the time required to thoroughly review the conviction integrity. So this bill would establish a statewide unit that can focus on these cases as well as make the respective prosecutor that originally handled the case available to review those cases. And this review unit will consist of 2 attorneys hired by the executive director of the Missouri Office of Prosecution Services, an investigator, a paralegal, and other administrative staff. The director shall be an ex officio member of the unit, and basically the only difference in this bill that we've added was the cocaine crack disparity language that we passed last year as well, and we just want to make sure that the guidelines for our justice system is fair and that this disparity is put in the past.
Any questions for Senator Williams? Seeing none, first witness in support of Senate Bill 765.
Mr. Chairman and members of the committee, I'm Darrell Moore, Executive Director for the Missouri Office of Prosecution Services and the Missouri Association of Prosecuting Attorneys. As Senator Williams alluded to 2 or 3 years ago, we did pass a provision making it clear that prosecuting attorneys could bring an action to declare a person actually innocent in 547.031. The next step that we need to take to make it clear is, as the Senator has pointed out, we have 2 out of the 115 prosecution jurisdictions that are large enough and have a budget enough to actually conduct investigations. Well, we have worked with the senator and others on over the last 2 years is this bill to expand it to put that responsibility for the other 113 jurisdictions in the Office of Prosecution Services. This is similar. We've researched this. In fact, I'll be honest with you, we wrote this bill in this language and worked with the senator in writing it. We're very comfortable with it, and it would be similar to what some other states do, where a statewide entity actually has the authority to investigate claims of actual innocence and then make the report to the appropriate prosecutor for them to decide whether they want to proceed or not. In terms of the proposed amendment on powder and crack cocaine, again, we supported that last year. We need to remove that. There's no reason to treat crack cocaine different from powder cocaine. Unfortunately, as you all, well, some of you are probably not old enough, I'll say that. Some of us are older and can remember in the 1980s, when I was a young assistant prosecutor, the hysteria that hit the country because of the use of crack cocaine. Unfortunately, not based on science, laws were passed to punish crack possession more harshly than powder. We now know the science does not support that, and so not only does our association, but the National District Attorneys Association and the Association of Prosecuting Attorneys supports removing the difference between the two.
Any questions for Darrell? Seeing none, thank you for your testimony. Further witnesses in support?
Good morning. My name is Ben Faber. I'm here on behalf of the Missouri Association of Criminal Defense Lawyers. We also support this bill. I'm pleased that MOPS has authored it with the legislature. So that's kind of unusual sometimes that we agree with the prosecutors, but it kind of highlights what I have to say today, which is the most effective way to get something done in the courts is by agreement. When you have the defendant or the criminal defense attorney and the prosecutor that both think that the right thing is, for a person to be exonerated, for example. If that's achieved, then the exoneration can be done much more quickly than it can through the court system. If we're looking at the litigation that's involved with someone who's claiming that they're innocent or that they're wrongfully convicted or something like that, the standards are incredibly high. The actual innocence standard in Missouri, you have to prove to the court not only that you actually didn't do this thing, not that there was some sort of misconduct or that they didn't do it the right way or that maybe you didn't do it or that you probably didn't do it, but that you actually didn't do it and that you have exhausted all other remedies. We're talking 10 plus years from a person to go from a trial conviction to an exoneration through multiple courts. Most people don't have the finances to do that right now. That pathway is done mostly by the Innocence Project and by pro bono attorneys. Having the state prosecutors on board and the Attorney General's office on board to investigate these claims can bring a much more efficient outcome to these individuals who have been wrongfully convicted and also settle some issues where people are not wrongfully convicted. I expect that there would be cases that go before this conviction review unit that are not people who didn't do the thing. And that may be the determination. But for there to be an independent review of these cases, we think is favorable for the justice system, and MACDL supports this bill.
Any questions for Mr. Faber? Seeing none, thank you for your testimony. Further witnesses in support?
Good morning, Mr. Chairman, members of the committee. My name is Jeremy LaFavor today, here appearing on behalf of Empower Missouri, and I think our good friends at the Prosecutors Association and the defense attorneys have done a great job. We'll submit some written testimony with some information on it for folks to dive into deeper, but we want to register our full support. We appreciate the Senator's leadership and hearing this bill today.
Thank you for your testimony. Any questions for the witness? Seeing none, thank you.
you.
Further witnesses in support? Seeing none, any witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on Senate Bill 765. Next up, Senator Williams, Senate Bill 861. I think we already heard the testimony from the bill sponsors, so we're going to go ahead and start right with witnesses in support of Senate Bill 861. Witnesses in support.
Mr. Chairman, Darrell Moore, Executive Director of the Office of Prosecution Services and Missouri Association of Prosecuting Attorneys. This is another bill that we've been pleased to work with Senator Williams on, I don't know, 4 or 5 years, Senator, and working with the expungement clinics, the defense bar, and many parties trying to put this together to make it workable. I know I appreciate the comments from my friend from the Missouri Association of Trial Attorneys that prosecutors and defense attorneys don't always agree, but I think ultimately we're all in agreement that the cause of the system of justice is to provide justice, and prosecutors are usually thought as unfortunately in our society, some people that are evil people that just want to convict people. But if you read the ethical code and the federal and state court cases, as prosecutors we're reminded constantly that our primary role is to be a minister of justice for everybody in our communities. And so in working on this expungement bill, I think we have crafted as a prosecutor for almost 30 some odd years, I would just tell you that the vast majority of people that we deal with, in the grand scheme of things, are not evil people. They are people who have done stupid things, committed crimes, that do need to be held responsible. But we don't always send them to prison. You know, prosecutors help create drug courts. We've created DWI courts. We support mental health courts, veterans clinics. We're in the role of, we want to protect our citizenry, but for those who commit crimes, if possible, we want to find a way to help restore them to be productive, law-abiding members of the community. This bill does that because there's 2 key provisions in it that we are in agreement that if we want to increase our workforce and restore people to their rights, the first group of people that this bill expands the possibility for expungement to are young people who commit crimes between the ages of 16 and 25. And I can tell you, that was my experience as a prosecutor. There are a lot of young men with no guidance go out and do stupid things. And then we need to keep in mind when we're talking about expungement, we're only talking about those offenses that are allowed to be expunged. We're not talking about the murders and the robberies and the rapes and the sex offenses. We're talking about the other crimes. And so the first thing we want to do is help restore maybe a young man who was 19 that went out and committed a series of eligible crimes, whether it was stealing or some other crime like that, that is eligible, that if they have done their sentence, whether it's probation or jail time or prison, they've paid restitution and they've been law-abiding citizens for 10 years after the completion of their sentence, that they should be fully restored. And they should be eligible to have any of those eligible offenses that were committed when they were 16 to 25 wiped off their record, so that that helps them to get more gainful employment opportunities, housing, etc. The way the statute is currently written, which makes no sense to me personally, and I finally persuaded my colleagues in the Prosecutors Association, is why should you, if you're a young man and you racked up 5 felonies that are eligible for expungement, and you only get to expunge 1 or 2, what good does that do anybody? Does no one any good. And so it makes no sense. So that's one provision that we strongly support, especially since it is the goal of the governor and the state in general to help restore people to responsible citizenship and create greater opportunities so that they're available for the workforce. And we all know the importance of trying to add to our workforce. The second provision that broadens the expungement criteria is for those people who suffer from some serious drug addiction, people that would be going into our drug courts. And they actually have a drug dependency that can be determined by the court. I know there's been some concern expressed by one group about who would make that decision. Well, the reality is our judges make that decision every day. They make decisions on whether or not a person is mentally competent or not, whether a person is suffering from a mental disease or defect, so that when a petition is filed alleging that a person suffered from a drug addiction that meets the DSM-5, I guess we're on now, that they're eligible to have all of those convictions while they were under a drug addiction. But again, they have to go through a period of 10 years after completion of their last sentence before they're even eligible. 10 years of being responsible citizens, not committing other crimes. I will just tell you that for the association, and to be honest, for me personally, those 2 pieces are critical if we really want to help people recover and become law-abiding citizens. And I believe that the one phrase that concerned the governor, and rightfully so in retrospect, even though this bill was filed in December of 22, and all parties had an opportunity, and we requested feedback and thought we had an understanding and agreement, but after the bill was passed, it was brought by our attention by a group that there was one wording, I think it's on page 5, subdivision 3, or subsection 3, subdivision 3, regarding sex offenses, where the original language was any offense that requires registration as a sex offender is not eligible, and we had changed that wording to any offense that at the time of the conviction, and that created an issue for the governor, but that phrase is being removed and takes us back to what the law is. So I would strongly encourage, well, you had no problem passing this bill last year, so I do not need to encourage you to do anything. So that'll be the end of my remarks. I'll be glad to take any questions.
Thank you, Daryl, for your testimony. Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 861.
Yes, good morning. My name is Ben Faber. I'm testifying on behalf of the Missouri Association of Criminal Defense Lawyers in support of Senate Bill 861. I had a client about 6 months ago, we'll call Sean H. Sean H. sold crack. Well, he got caught selling crack twice. He probably sold crack more than twice. But he got caught once on August 15th of 1990 and once on November 7th of 1990. So a little more than a month apart, about 5 weeks apart. Same county. His testimony at the hearing on the state's motion to dismiss his petition for expungement was that it was the same substance, the same customers, the same everything. He's out there on the streets selling drugs in 1990. Since then, obviously, he's changed his life. That's why we're asking for an expungement. He's working. He's never been in trouble other than that time, but he did want to expunge these 2 convictions so that he could, have more job opportunities. He's self-employed doing construction and remodeling right now, which he enjoys and does well with, but he's looking for other employment, so he wanted to expunge these 2 felony convictions that were based on sales of a controlled substance approximately 5 weeks apart. Because one of those sales was to an undercover police officer, the conduct was withheld as far as prosecution went, so they didn't prosecute him until about 1.5 years later when he got busted again. Then they brought up the old case. The basis of the state's motion to dismiss was that these 2 offenses were not part of the same course of conduct. Under the current expungement bill, 610-140, an individual can only expunge 1 felony conviction unless it's part of the same course of conduct as other felonies. This circumstance, the state argued, was not the same course of conduct. They based that on a case called SP versus St. Louis County Circuit Court. In that case, an individual passed 6 bad checks in 4 different municipalities in the St. Louis area over a 20-day period. She tried to expunge those 6 convictions, and in the Court of Appeals, so this is the current law in Missouri as to the course of conduct, the Court of Appeals said that it was not a continuous course of conduct. Again, 6 bad checks, 20 days, 4 counties, same area. And they based that conclusion on a double jeopardy analysis, which is very, very strict, right? The double jeopardy provision of the United States Constitution essentially prohibits someone from being charged with 2 crimes for the same thing. But if they're in the room and they punch 2 different people, that's 2 counts of assault. It's the same course of conduct. It's not double jeopardy, and so the courts have, over 200 years really narrowed that down so that people will be held responsible for separate criminal acts. But the expungement situation is different. We're not looking to hold people responsible for separate criminal acts. We're looking to expunge similar criminal conduct. And so Sean H. was in this jam where there was a lapse in time between these 2 actions, and it fell outside of a double jeopardy analysis, so he was charged in 2 different cases, which was appropriate. What the amendments to this bill do to 610-140 is that it adds a definition for continuous course of conduct using the language common connection. And it limits that to a year. So there's got to be a common connection between the offenses, the multiple felony offenses that a person is seeking to have expunged, to a period of 1 year. So that kind of fixes that issue we have with using the double jeopardy analysis for a course of conduct determination. The other thing it does is it defines and allows expungement for an extended course of criminal conduct, which MOPS, by the way, we're 2 for 2, MACDL and MOPS today agreeing. That's exciting. It defines extended course of criminal conduct to include all convictions for an individual between the ages of 16 and 25, which is when especially young men have I call it a lizard brain when I'm dealing with sentencing issues, and the research is that especially a male brain isn't fully developed until the age of 26, and they're prone to all types of unexplainable behavior, often criminal. But it also allows for multiple felony convictions to be expunged if it is based on some sort of addiction. Now, maybe a compromise, but something interesting about the 2 provisions, the course of conduct provision, especially the extended course of criminal conduct provision, is that it changes the look back from 3 years to 10 years. So if you're trying to expunge more than 1 felony conviction, this I made 1 mistake thing, you actually have to show a pattern of behavior over a much longer period of time. Right now it's a 3-year look back for felony expungements and a 1-year look back for misdemeanor expungements. It doesn't change it because it doesn't exist, but for these people who are trying to expunge an extended course of criminal conduct, it makes it a 10-year look back. So I think that's notable. It does not remove the limits on expungements that fall outside of those 2 areas. It's still 1 felony, 3 misdemeanors, unless it's similar course of conduct. 1 quick example, I'm almost done. I know I've kind of, okay. Another specific situation, individual passes 2 bad checks, 2 different counties, a day apart. Those are 2 case numbers. Currently, they would not fall under the same course of conduct. I have a friend with this situation with that specific circumstance. This guy can't own a firearm because he's a convicted felon. He's in his 60s. He wants to hunt with his grandkids. He bow hunts, but he wants to deer hunt with a rifle, and he's not able to. So we very much so support this bill. Thank you for your time.
Thank you. Any questions for the witness?
Yes,
Senator May,
yes.
go ahead.
So, clarification. So basically, this is a hypothetical because you said a lot, but you're telling me if I have 5 felonies and I want to get all 5 of those felonies expunged, I can't go in and get them all expunged if they're not continuous.
Correct. If they're not in the same case number, the state, whether it's the prosecutor's office or the attorney general's office, will file a motion to dismiss. They've got to be in the same case number.
Why? I mean, what if I committed 1 crime when I was 16 and then, maybe I committed 4 when I was 18?
I don't know why. I mean, that applies if you commit 2 crimes on 2 separate days. It's the same crime and you're 16 for both crimes. That's the current state of the expungement law, and so that's
Those are barriers. I don't understand that. What's the purpose of expungement if I can't expunge them all?
well. So
Well, that's why we're looking to remove the cap.
Okay, very good. I'm just making sure.
Yeah, and as you stated very well, sometimes you can get 1 incident and get multiple charges. In the past, I'm assuming it was treated almost as if they were separate incidents, correct?
right.
So this will address that, Senator May.
Any further questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support?
Thank you. Oh, we got 'em. We don't go into two.
Good morning, members of the committee. Philip Arnzen with the Missouri Chamber of Commerce and Industry, and we support policies that allow for expungement of certain offenses. We believe that folks deserve a second chance, and it's important to make sure that they can reenter the workforce and have gainful employment. In our most recent public safety report, Safer Missouri, Stronger Missouri, one of the data points that we found was that gainful employment was actually one of the biggest predictors of recidivism, and that if somebody was had stable employment, they were less likely to enter the justice system again and were able to just live a productive life. So we just like to go on the record in support, and I'll take any questions.
Any questions for Phil? Seeing none, thank you for your testimony. Further witnesses in support?
Good morning, Chair and Committee. My name is Kurt Wickmer, and I represent the Missouri Catholic Conference in support of this bill. We appreciate measures like this that encourage any willing offender to reacclimate to lawful society, as long as they show the willingness to do so. We'd like to thank the Senator for putting this bill forward and open myself up for questions.
Any questions for the witness? Seeing none, thank you for your testimony. Thank you. Further witnesses in support? Seeing none, any witnesses in opposition? Seeing none, any witnesses for informational purposes?
Good morning, Mr. Chair, members of the committee. Eric Jennings, Government Relations Counsel for the Supreme Court, on behalf of the Judicial Conference of Missouri. We have one request for the committee to consider, and this is sort of a general request on any expungement bills. This one, being petition-based, is not as problematic, but we would request a delayed effective date on these just to accommodate the amount of time it takes to handle the programming in court automation, so that we make sure that it's carried out effectively in the manner the legislature intends.
Does the court have a proposed delayed effective date that they would like to see?
As a starting point, January 1st would at least be a sensible date, I think, but we're quite willing to talk to the sponsor and you and the rest of the committee and determine whatever you determine
So
would be.
it's basically a 6-month delayed effective date. Okay.
As it stands, we may have as many as 45 days from knowing the governor signed it to when it
Yeah.
actually takes effect.
I could see that being an administrative nightmare to implement if you have that short of a runway. So that makes a lot of
We've
sense.
learned a few things from Amendment 3.
Yep, that makes sense. Yes, for sure. Any questions for Eric? Seeing none, thank you for your testimony. Thank you.
Forgive me.
Senator Coleman.
Eric, thanks for being here to testify. Just from a technical standpoint, one of the things that's been testified in the past on expungement bills has been the poor quality of our data in general, and that a lot of the court case documentation is pre-electric filings. Or do you have those same concerns for this bill, or have those problems largely been solved after Amendment 3?
I think part of what we're looking at here is making sure that things are programmed properly at the beginning, so that if we do need to go back at any point to look at things, that we have all the data in order to run the reports to find the information that we need to find based on what the legislature is directing us to do.
Okay, I appreciate it. We're built on Cobalt systems apparently, and it makes me crazy, so thank you for your testimony.
Thank you.
Any further questions for Eric? Seeing none, thank you for your testimony. Further witnesses for informational purposes only. Seeing none, I'll conclude the hearing on Senate Bill 861.
Thank you.
Next up, and the last bill for the committee today, is Senate Bill 887. Senator Washington, whenever you're ready.
Good morning, Mr. Chair and committee, and thank you for having me today. Today I'm presenting Bill 887, which was part of a comprehensive bill last year, Senate Bill 189, that we truly agreed and finally passed, but was the only bill that was vetoed by the governor. This bill is simple. Currently, juveniles that are charged with crimes between ages 12 and 18 can be subject to a hearing to certify them as adults. I'm asking that we move that number up to 14 to 18. I'd like for it to go higher, but I know we can't get that done because studies have shown that children that young just don't have the capacity to know what they're doing. And so I'm asking that we kind of move that up, even though statistics show that we have not had a lot of 12-year-olds in the state of Missouri that have actually been certified. We do have those children who have psychological damage for the rest of their lives by just going through a hearing, because it is set up just like a trial. We will still exclude the 7 deadly sins, and we would add mandatory hearings for manufacturing of controlled substances and dangerous felonies. With that, I'll take any questions.
Any questions for Senator Washington? Senator Rader.
Thank you. You and I agree on this, and you know how we've talked about it. What is that average age across the U.S., or do you know that court
I don't know
certified?
the average age, because every state is different with the age that they prosecute young people.
Okay, because I feel like
So
12
like
is
California
really
would
young.
probably have a lot more young folks, but they don't certify them as young as we do, just because California and Chicago have more well-known gangs. And so they tend to go after younger children, but those children are not, they're not certified the way we do.
Gotcha. Okay. Thank you.
Further questions for the bill sponsor? Seeing none. First witness in support.
Good morning, Chairman Luke Meyer and members of the committee. My name is Susan Rennie, and I am testifying on behalf of the Missouri State Public Defender System today. Our director, Mary Fox, could not be here. I am testifying in favor of the bill. I've been with Missouri Public Defender for about 18 years. I was served as a trial attorney most of that time. I currently supervise the Special Practices Division, and that includes 2 specialized children's defense teams in Kansas City and in St. Louis. In addition, previously, some time ago, I served as an attorney for the 5th Judicial Circuit Juvenile Office in Buchanan and Andrew counties, so I have been on both sides of the courtroom when it comes to children and delinquency matters. We at the Public Defender System are in favor of this bill because it recognizes that children under the age of 14 are truly children, and they should be treated as children. Specifically, this bill protects children at those tender ages from being transferred to adult criminal court. I'm trying to talk a little bit louder. I don't think it... Is it okay? Thank you. So we believe children at the ages of 12 and 13 and below should stay in juvenile court because the goal there is to rehabilitate them. And if we can take a child who has done something wrong, even something seriously wrong, and cause that child to be rehabilitated, to change his or her ways of thinking and ways of acting, then we are all the better for that, and we benefit. And we know that children can be rehabilitated. Several people this morning have already talked about the brain science that says that children and adolescents just think in very different ways than adults do, but the science has shown us, some of the most exciting science in recent years, the past 20 years or so, has shown us that children's and adolescents' brains are incredibly plastic. They are able to be molded and shaped and changed in very dramatic ways. We have learned that there is huge potential for children to change during this time, and that potential is there in every child. It is a biological fact, and in a sense it really defines what it is to be a child or an adolescent. We know this from scientific research, but we also know it from common sense, from the children that we all know roughly in the 6th, 7th, or 8th grade. I think most of us know just how immature those kids can be and how much they can change within even a couple of years. Research on brain development tells us that this period of rapid and dramatic brain development continues until we are in our early to mid-20s, and that means that at the age of 12 or 13, we have about 10 years where this child a child would be really able to be rehabilitated. So it's a long period of time for improvement. And our juvenile system in Missouri does a good job of rehabilitation. Missouri's juvenile justice system has been recognized nationally, particularly our Division of Youth Services, which has actually served as a model for other states. As I understand it, this statute originally did have a certification age of 14 that was lowered in approximately 1995, but we have learned so very much since 1995 in terms of brain development. In 1995, for certain crimes, children were actually even able to be sentenced to death. The United States Supreme Court has recognized the problems because of the developing brain science, has recognized the injustice in that. And so now, in fact, children cannot be sentenced to death by federal law and cannot even be sentenced to mandatory life without the possibility of parole. So a lot has changed since this statute made 12 years of age the minimum age for certification and transfer to adult court. This bill, number 887, recognizes those changes, recognizes the potential and the power of rehabilitation for children, and keeps children under the age of 14 in children's court, and we believe that's where they should be. Thank you.
Thank you for your testimony. Any questions for the witness? Seeing none? Thank you for your testimony. Because we are running a little long on the hearing time, and I want to make sure that we have enough time to still have an executive session at the end of this, we're going to limit further witness testimony in support to 2 minutes per witness. So next witness in support. And it is acceptable, by the way, and in fact encouraged in this committee to say me too if you just agree with the testimony from the prior witness. So just, you do not get paid by the word in this committee. So, Mr. Faber.
Me too.
That was excellent. Seeing no questions from the committee, next witness in support.
Good morning, Mr. Chairman, members of the committee. My name is Marcia Hazelhorst, and I am the Executive Director, of Missouri Juvenile Justice Association. We too are here in support of Senate Bill 887, so I will add me too, and I will also just, I would like to answer Senator Rader's question about earlier. At least in looking at Missouri data, the average age is at least 16 or higher. Missouri hasn't certified a young person under the age of 14 since 2011. So again, the average age, especially with raise the age of the juvenile court jurisdiction raising to 17, we've seen an increase in 17-year-olds being certified, but almost all youth are pretty much in that 16 on up age. Thank you.
Questions for this witness? Seeing none, thank you for your testimony. Further witnesses in support.
Senator, Mr. Chairman, members of the committee, Jeremy LaFavor appearing today on behalf of Empower Missouri. We just want to go on record. Appreciate your hearing it. Thanks.
Okay. Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support. Seeing none, any witnesses in opposition?
Different comment.
I was going to say, you can't testify twice, Jeremy. Any witnesses for informational purposes only? Seeing none, that will conclude the hearing on Senate Bill 887. We'll now make a motion that we go into executive session. Do I have a second? It's been moved and seconded. You guys have it. We are in executive session. I would now make a motion that we bring up before the committee for consideration Senate Bill 754. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. Senate Bill 754 is before the committee. I would now make a motion to bring before the committee, and we will have a discussion here once we do this, to bring before the committee Senate committee substitute for Senate Bill 754 et al. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. The committee sub is before the committee. So we circulated this to the members this morning. I know I've had conversations with every member of the committee leading up to this. All of the provisions that are in the committee substitute are either identical to or substantially similar to what the legislature TAFP'd last year in Senate Bill 189, as has been referenced by several of the witnesses today. That was the bill that was vetoed by the governor. These are the provisions that were either not objected to in the governor's veto message or provisions that have been modified to address objections in the governor's veto message. I'm happy to walk through it if the committee members would like me to. Again, normally we would, wait for a week after hearing some of the bills we heard today, but given the familiarity of the issues since this bill came through the committee on at least 2 different occasions last session, was debated on the floor and passed by the full body, I didn't feel the need to rigidly adhere to the requirement of waiting for a week before we exec out. So with that, I would open it up for any discussion, and like I said, I'm happy to walk through the provisions if anybody has any questions. Senator Coleman.
So thank you for reaching out to the committee. We had a brief discussion as well. I am not going to be in support. I tend to think that we should stay the course of what we typically do. I get why you're doing it. I'm not making a big stink about it, but I'm going to be a quiet note. Just wanted everyone to know.
Sure. Further discussion? Okay, I am, before I make the adoption motion, I had an offline conversation with Senator May, and we're going to be separately voting out Senate Bill 760, which is her legislation. The committee substitute that was circulated had her bill number rolled into it, so I'm going to be making a motion to remove that, add 2 bill numbers for bills that were heard last time and today, with the permission of those bill sponsors. And then my intention would be to adopt the amended Senate committee substitute. And then we will proceed to vote separately out Senator May's bill. So with that, I would make a motion that we amend the Senate committee substitute that's before the committee to remove Senate Bill 760 from the bill string and to add to the title Senate Bills 746, which was Senator Bernsketter's bill from last week, as well as Senate Bill 861, which was one of Senator Williams' 2 bills that he testified on today. With that, I would make a motion to adopt the amendment. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. You have adopted. Now I would make a motion that we adopt the Senate committee substitute for Senate Bill 754 et al. As amended. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those the contrary, no. You guys have it. You have adopted the Senate committee substitute as amended for Senate Bills 754 et al. I would now make a motion that we do pass Senate committee substitute for Senate Bill 754 et al. Do I have a second? It's been moved and seconded. Please call the roll.
Senator Lukemeyer?
Aye.
Senator Schroer? Senator Coleman? No. Senator May?
Aye.
Senator Roberts? Aye. Senator Thompson Rader? Aye. Senator Trent?
No. By your vote of 4-2, you have voted do pass Senate committee substitute for Senate Bill 754 et al. I would now make a motion that we bring before the committee Senate Bill 760. Do I have a second? It has been seconded by Senator May. All those in favor signify by saying aye. Aye. Those the contrary, no. The ayes have it. Senate Bill 760 is before the committee. Is there any discussion? There is no committee substitute on this, so it's just the version of the bill that was heard.
Can I remind everybody what
Yes,
it is?
Senator May, if you want to explain the bill.
Yeah. Senate Bill 760 is similar to what we did for the police officers for mental health. The firefighters wanted to be included in the mental health option that the police officers had. So that's all we're doing. Nothing else added. And I would appreciate your support for the bill. Thank you.
Any further discussion on Senate Bill 760? Seeing none, I would make a motion that we do pass Senate Bill 760. Do I have a second? It's moved and seconded by Senator May. Please call the roll.
Senator Lukemeyer?
Aye.
Senator Schroer? Senator Coleman? No. Senator May?
Aye.
Senator Roberts? Aye. Senator Thompson Rader? Aye. Senator Trent?
By your vote of 4-2, you have voted to pass Senate Bill 760. I would now make a motion that we exit executive session. Do you have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. Ayes have it. We are out of executive session. I would now make a motion to adjourn. Do I have a second? It's been moved and seconded. We are adjourned.